our next session is about litigation and steps you need to do, et cetera, when you have a claim, who to talk to, who not to talk to, what your responsibilities are, all that kind of stuff. This was originally planned to be one of our quarterly webinars, and it got canceled, so we were happy to have Josh step in and present here today. So Hasib will give a little bio. So thank you.
All right, well, Josh Walker, he's a managing partner of Walker Revels, also a retired Army general, and has been Major. Sorry. I give you a little more, too much credit there, but no, Josh has been involved with FIT for a number of years now, has been involved in defense of many of our complicated cases, is now serving as our litigation manager. So he's involved with any of our litigated files in terms of oversight of the defense counsel and our strategies associated with that. So with that, Josh.
Thank you. All right, welcome. This is the part that everybody likes, where we get to talk to a lawyer. It's wonderful, right? For free. Right, this is free? We'll come back to that. Anyway, nice to see all of you all. I've had a chance to work with quite a few of you over the years. So this is kind of a short presentation today. There's a couple of things that we're going to talk about. One thing that we just wanted to get back to the nuts and bolts on is loss investigations. How do we handle them? How do we standardize them? What's a good process, and why do we do that? So we're going to offer a few examples, kind of some tips of things that work well as compared to things that don't, and really tie that into why and why does it matter. We've got a few hot topics that we're going to talk about at the end that have been coming up over the course of the last couple of years. And then we're going to have a little bit of an open session too. And I'm sure typically every time we do this, the open session, there's quite a few questions that have come up. I will, if I don't remember to tell you at the end, I'll tell you now. My contact information, I think it'll be on here. A lot of you already have it. If not, happy to send it to you. If you ever have any questions, doesn't matter if you have a claim open or not, you can always email me or call me, and if I don't have the answer, I'll try to find it for you. Because what we try to do is get ahead of some of these issues early so we can avoid some of the claims down the road. So, brief topic today. We're going to be talking about loss investigations, how we do that, how do we gather and preserve evidence. We're going to talk a little bit about reserves. And the reason for that, as we'll get into, is just that you have an understanding of your loss reserves, why it's important to set those accurately, and how that helps you and how that helps the program. And then the hot topic is where I think we're really going to get into some interesting questions. And I'll be on the hot seat to try to show that I know some information. So we'll see. Okay, so I want to start with a hypothetical example that may have occurred within the last year. So you have a residential facility, and you have some clients that are court ordered to be at that facility. It's a full-time lockdown facility, and one of those clients develops a relationship with another one of the staff members at the facility. Because you can't always control where Cupid's arrow hits, right? When love is in the air, sometimes it just happens, but sometimes it happens in the worst of settings. So let's say that occurs, and before you know it, and your first notice of that is when the sheriff's department comes knocking on the door, and there is a criminal investigation, and you found out it doesn't involve one client, or two, or three, or four, but five over the course of the last 6 months. And you have the sheriff's department that's in, you have the regulatory agencies that are in, they're conducting your investigations, and your entire team is on the forefront of responding to the detectives as they're coming in to interview your employees, responding to the regulatory authorities, whomever that may be, depending upon the facility that you have, and fielding those questions. So your risk management team is very, very involved in that front, because you've got a criminal investigation, you've got licensing issues that are going on, all hands on deck, except for the liability piece that hasn't really been thought about, because everyone is scattered to the winds trying to put out the fires and answer the questions for everyone else who's looking into this. These things happen, And before you know it, it'll be 6 months or a year or 2 or 3 years down the road before you get your first notice. Maybe it's a letter of representation from Morgan & Morgan. Now you've got some lawsuits that are coming. Well, we already did the investigation, right? We already preserved everything, but did you? Granted, you have information that's preserved through the Sheriff's Department. You have information that may have been submitted to the regulatory agencies. But what has been done to capture that from a litigation standpoint? And what can you do to gather that information in a way that's protected so you're not waiving privilege? These are some of the issues that we've seen over the last few years, and so we thought it would be helpful to kind of talk about internal processes, what makes sense when you have a loss. The most important thing is to notify, right? So you need to notify your agent, notify your broker, make sure you run that up the chain so that there is a record that shows, hey, we had a loss, we can make sure we have the appropriate resources in place to help. Your risk management team probably varies from agency to agency and who you have on it. You're probably going to have your risk manager, you may have quality assurance, you may have the person who holds that job along with 3 or 4 other jobs depending upon the size of your organization. And sometimes that can be hard to have all of the people in place to gather all of the information that you need. For claims where there are big losses, if it's timely reported, we can bring counsel in if needed to help steer and quarterback that investigation, which does a couple of good things. One, it kind of helps us all talk together, make sure we're interviewing the right employees, we're getting sworn statements, recorded statements. We're doing that under the umbrella of attorney-client privilege, so that you're not later down the road having to turn over information to a Dan Newland lawyer that you wouldn't ordinarily want to have to do. But timely reporting on that is very, very key. But the team should be spearheaded by someone, obviously, who knows what your internal processes are. So maybe you have an incident reporting form, and that goes through levels of review from the witnesses that are involved to the supervisors to the risk management team to make sure that process is followed. Sometimes, as we'll get into this, of what you need to gather for these things. So witness statements, obviously important. Photographs of the scene. I mean, it happens more often than we care to admit. If there was an accident that happened at a facility, was there surveillance? Sure, there was surveillance. Do we have it? No, we don't. It could be a problem. Same thing with photographs. Do we have it? Somebody took the photographs. Well, great. We have photographs in the file, and it's 3 years later, and so we see these things that are in the file. But who took those, and when were they taken, and where were they taken? Was it before or after? All of these things that we can do to document the losses ahead of time really help to mitigate down the road. It helps your defense counsel later down the road, and could be 3 or 4 years down the road before they get involved, to recreate this picture so we know exactly what happened and how it happened. A lot of you have probably heard about ESI, electronically stored information. This has been, for the last probably 10 years, a really hot topic in the legal field. Federal courts started having ESI orders come in. State courts have now started to do the same. And the reason for that is because plaintiffs' attorneys, frankly, they attend these seminars and say, how do we make litigation more difficult and costly for the defense? And this is a big way to do that. And so we've seen more and more and more an increase in requests for emails. And not just the emails. I don't want you to print out your emails. I want the metadata for it. Same thing with the surveillance. You gave me a surveillance. I don't care. I want to see the underlying original metadata for that. How do you preserve that? Who do you have on your IT team at the beginning of these loss investigations that can make sure you've captured and you've stored that information? And then how do we preserve that and put it somewhere where it doesn't get lost 3 or 4 years later? We see this a lot also in auto accidents. We have seen, as Shane pointed out, a decrease in auto claims, which is great, as far as a decrease in the number of claims, but an increase in the severity of the claims. So what happens when you have a vehicle that's involved in an accident? What if it's not even a company vehicle? What if it's one of your employee vehicles that was involved in a significant accident and it's not in your control, and now the vehicle's gone before we have a chance to bring an expert that can come in and can pull the data download and scan the vehicle and take the photos? All of these things help to drive the loss down if we can preserve that information at the earliest. But electronically stored information, you'll hear more about that now that the state courts are starting to really push that a lot harder than they used to. And you're going to start seeing it. I always sheepishly have to pick up the phone and say, they're asking for emails, and I'm going to fight them, and I'm going to object every way that we can, but we also need to start thinking about what we can do to start gathering those. And sometimes that can be costly. And sometimes you have to bring experts in to gather all of that. Fortunately, right now, the judges are keeping a pretty even balance on that and not letting the cost drive the litigation too high, but we're seeing a trend that it's increasing. So all of this ties into reserve setting. I guess by a show of hands, who here has been involved in conversations on open claims about the reserves and trying to understand why the reserves are set high or set low? Yeah, it's pretty frequent, right? So what does that mean, and why do we do that? I can tell you that for the different carriers that I've worked with over the years, there's kind of a spectrum. You'll see carriers that say, well, we always set the reserves really, really low because we don't really know what the value of the claim is. Maybe they're claiming $1 million, but we don't think there's any liability up front, so we're going to set them really low. And then what happens is the case that might have a real value to it goes through the defense process. It's racking up defense costs. Your defense attorneys are having to do a lot of work because we're not going to pay $40,000 on a claim that is no liability. And then after a year or two of litigation, now you go to a mediation and you've incurred $30,000, $40,000, $50,000 in defense costs, and then you settle the claim for $40,000, right? So now on your reserves, on your loss runs, now your defense costs are higher, and the indemnity that you paid is still the same. So how do we be accurate in that? We don't want to overshoot it either. So we got another $1 million demand from Dan Newland today for someone who, slipped on a puddle of water in the parking lot and stubbed their toe and broke a toenail. Another $1 million demand. Does that mean we set the reserves for $1 million? No, of course not. But it all ties back into the investigation. Even on the smaller claims, the claims that aren't going to have a lot of value, everything that you can do to gather that information up front, report it up through your broker, report it up to the carrier, will help us to set those reserves accurately. And that helps for strategy decisions too, right? So how do we know how we're going to litigate this claim? You don't want to pay on every claim. There's claims that you absolutely want to defend, but you got to be able to differentiate those that you pay on versus those that you need to resolve early, and those that you need to try. There's some that just have to go to trial. So I know as far as the loss reserves go and setting the accuracy of those, I know that's important. I don't know, Steve, if you have anything you wanted to chime in on that front. Are there any questions on that piece? I know it comes up pretty frequently in some of the calls that we have. Anybody have any questions on setting reserves on these claims or difficulties that you have in trying to understand how those get set? Now's a really good time to ask that if you do. Okay. This is going to be primarily...
Josh.
Yes. Sure.
The thing that may help everybody, use and I often use, is everybody knows we're in the same building with Morgan & Morgan, so we see those guys all the time. Being a defense attorney, does it make a hoop for you, whether it's Morgan & Morgan or somebody else who's not known to have as deep of pockets, because Morgan & Morgan just changes every ambulance in the world. So, I mean, do you take that into account when you're setting a reserve?
Somewhat we do. It depends on the firm. It also, of course, depends on the attorney that's involved in the firm. There are some attorneys that we know are just going to litigate over every small thing, and they are going to drive the defense cost higher. We factor that in where we can, the best that we can try to evaluate that. But on the whole, there's not a big difference in the way that these claims are handled, whether it's Dan Newland's office or Morgan & Morgan's office, other than some of the bigger picture strategy where you see that they refuse to settle claims. They're not going to settle the claims pre-suit, for example. Some of the bigger plaintiffs' firms will find out what your insurance coverage is and will make a demand for those policy limits no matter what the value of the claim is. Anybody have an idea of why some plaintiff's attorney might want to do that? When they could settle the claim reasonably pre-suit, or they can make an unreasonable demand and file suit? Well, because their contingency fee goes from 33% to 40%, right? So if they settle the claim, if they settle a $100,000 claim before filing suit, the attorney will get $33,000. But if they make some unreasonable demand and then they have to file suit and then they settle it after that, well, now they get $40,000. So we see a lot of that. What we see, they don't like to talk about it, but Morgan & Morgan, for example, they've got, it's a very big law firm, I think. Seems like I've seen some marketing piece about the size of that firm. But they have internal committees. So they'll have lawyers handling files, and they're trying to work it through discovery process, and they want to get the case settled, but they can't. And they'll tell me, Josh, I'm sorry, I want to get this case settled. I know it's not worth nearly what we're asking for, but I haven't been able to get it in front of our committee. Or I've got it in front of my committee, and they said, no, we're just not going to let you settle the case. You think they involve their client in that discussion? No, they don't. I see this is being recorded, so I'm making enemies as I speak. But but that's what we see that is driving these claims. So we're not able to resolve them pre-suit, at least not easily. And when they do get into litigation, once it's in that process, it's hard to get out of it. Fortunately, the court systems they're starting to get back online. We're starting to have some trials, but they're really delayed. Through COVID shutting down, we still have some courthouses that are still shutting down. So trying to get through this backlog of cases right now has presented a challenge. I do want to note something, though, that's really helpful, and some of you may be aware of this and some of you may not. There was a really significant change in the law that took place July 1st of this year. And this relates to motions for summary judgment. And so for those of you that may not be familiar with that, a lawsuit gets filed, your attorney has to answer the lawsuit, it goes through discovery, and at some point in that process, there's an opportunity to file what's called a motion for summary judgment, which is where you say, Judge, even though the plaintiff has alleged all of these things, it's not true, what they've said is not accurate, and so we want you to just throw the lawsuit out. Before July of this year, on the defense side, we had the burden of disproving what the plaintiff would say. So if the plaintiff made an allegation, we had to disprove that allegation, which sometimes is very hard. Sometimes it's impossible to do. How do you prove the absence of evidence? That's a very difficult thing to do. Whereas in federal court, the rule has always been the opposite. So if you're at the summary judgment stage, as the defendant, you don't have to disprove anything. You can sit back to just say, they haven't proven it. It's their burden to prove it, and they haven't done it. And then that's why we see in federal courts that summary judgments are granted so much faster. Well, the law changed July 1st in state court this year, and the Florida Supreme Court came out and took a really hard look at this and instructed in very strong terms the trial courts to start granting summary judgments when the plaintiff does not have evidence to prove the claims. We're seeing this already taking off in all spectrum of claims. For example, I had a summary judgment motion on a premises case, somebody that was injured in a store. They picked up a punch bowl, shattered their hands, pretty serious injuries. Summary judgment was denied 2 times. Because our point was there was nothing wrong with the punch bowl until the lady slammed it against the shelf and hurt herself. It's not our fault, it's her fault. It's on surveillance, it's right there. 2 times that was denied. The new law changed July 1st. We raised it for the 3rd time, and it was granted. Case over. Hundreds of thousands of dollars in medical expenses. The court said it doesn't matter. There was no proof. The plaintiff was unable to carry the burden at the summary judgment stage. That is a really important thing, and I can't overstate that enough. It's the reason why for years, historically, we would always say, if you have the chance to get in federal court, which is hard to do, but if you have the chance to get in there, you have to, because you can actually resolve these claims. These frivolous claims, you can get rid of them without having to face trial and guess what a jury might do. But now that this is happening in state court, it's really helpful, really important for us at the front end of these claims as we're evaluating them. Sure, the plaintiff has alleged things, but are they true? And what do we have in our file? What have we documented in our file to show that it's not? Because everything that we can do now to start setting these claims up for summary judgment we're seeing the domino effect as they're starting to get knocked down. It's going to be a big game changer. It already has been over the last few months in the state. Tangent on summary judgments, but you'll hear more about that from your defense counsel as you have claims that are going on. So we want to talk a little bit about some of the things that have been coming up recently, and then we're going to open up. There's going to be plenty of questions, I know, on various issues. One thing, COVID-19 in the workplace. That's a broad topic. That can cover a lot of things. One thing that I just wanted to give everyone somewhat of an update on are the vaccine mandates, and where are we in that process right now, and what does it mean? Still a big question mark. So the administration signed an executive order 5 weeks ago, I think, indicating that any employer with more than 100 employees would be required to have a mandate of vaccinations in the office. So every employee has to be vaccinated, or they have to present, I believe it's at least weekly tests, a COVID test every week that they're there. You're starting to see, I think, preemptively some of the larger employers that are acting on this and creating their own vaccine mandates, and you're starting to see some of the headlines of people that just aren't complying, and what does that do to the workplace? So where are we? Where are we as far as procedurally speaking on that? So the executive order was signed. This is something that would be implemented through OSHA. So if there is the failure to comply with this requirement, then there are fines that are associated with that, along with other penalties. The OSHA rules just were sent night before last back to the administration. So the OSHA has now pinned those rules. They sent them back to the administration Tuesday night, which essentially tracks what I just said, which is, vaccine mandates, 100 or more employees, or weekly COVID test, fines, penalties. And then now that it's back to the administration, it goes to the OMB, so the Office of something in budget. Yes. Management and budget, yes, thank you. And so now this could be, I would imagine, sometime in the next couple of weeks, the OMB is going to officially sign off and release these rules, at which point lawsuits will be filed. Of course, you've got attorneys general that are going to be filing these lawsuits across the state, challenging the constitutionality of those. What happens at that point is anyone's guess. Some courts will probably allow it to go forward. Some courts will enter an injunction, and it's going to be a mess for a while. But in the meantime, if you have 100 or more employees, what do you do and how do you get prepared for that? It's difficult. I don't know. Other than to say, we are watching it. We're going to be putting out information as well as we have more information on it. And we're all going to be reading the news. But we're kind of looking at this internally as well to see how do we enact this? What do we do with it? One thing to be aware of, the way that the draft rules are currently written through OSHA, they emphasize whistleblower protection for employees who say, my employer is not complying with this. I am now a whistleblower. That is going to create probably more voluntary enforcement. And the reason for that is, of course, OSHA is significantly understaffed. I think nationwide they have 860-something investigators total. And so now, if you look at the number of employers that have over 100 employees, it's very, very daunting of a task to get someone involved in every one of those to see if they're complying. But if we're incentivizing whistleblowers to say, hey, they're not testing everybody every week, or they haven't required vaccines for everyone every week, now you're going to see that enforcement start to kick up. Yes, sir?
So what date are we legally required?
We don't know yet.
So we're okay right now?
We're okay currently, yes. Currently, that mandate is not in place. Now that like I said, now that the rules are written, they're the OMB's office. OMB will publish them. They'll then be published in the Federal Register, which is when they take effect. And we don't know. The rules themselves may have an enforcement date or an effective date for when they take place. But I don't know what that's going to be yet until it's written. That's right. Currently, the only thing we have is the executive order, which tasked OSHA to write the rules, which the rules have now been written, and then it will go. So the vaccine mandate is obviously it's an important question that we're still working through. I think I saw a hand. Was there another question on that? Yes.
One question, how, and I don't know about this either, but I know about a couple other states, how are they going to manage the unemployment issue of somebody that needs to get either tested or the vaccine?
You mean, does that person qualify for unemployment?
The answer should be no.
Yes, thank you. Sorry. The question was, from an unemployment benefit standpoint, what happens if an employee refuses the vaccine mandate and now they are terminated for their employment? Do they qualify for unemployment benefits? I don't know the answer to that. And I don't believe that those rules have been written yet either. I'm going to look it up too to make sure. But as of, I think 3 weeks ago when the executive order was first written, that was an open question. I don't think it's been answered yet. For Florida. Correct. Correct. Yes, sir.
And have they finalized the rule
The question is whether they have finalized the rule yet as to whether they will require proof of vaccination. Yeah, same with that too. So I know they have started. They've started to crack down on people who have fake vaccination cards, which started to be a bit of a cottage industry. As far as the proof of vaccination itself, I don't know if that is written into the text of the new OSHA rule or what it will come out when it comes through OMB. The answer is going to lie in that final rule when it comes out of OMB as to what the actual requirements are for inspecting to ensure that the employees are vaccinated. So do you take them at their word, or does the rule itself require some inspection of that as well? And I think what we're going to see, assuming that the rule does not require actual inspection, I think that's going to be the gray area that leads to some of the whistleblower complaints. They say everyone's vaccinated, but I know John down the hall's not, and how does that impact the employer's due diligence in ensuring that the employees are actually vaccinated? Rule's not yet written. Good question. Yes, ma'am. The question was, what about organizations under 100? Currently, the rule only applies to organizations with 100 or more employees in the state of Florida. Yeah, that's a great point. If the rule were to apply to all healthcare organizations, then that obviously expands the scope as well. Yes, ma'am.
The cost of weekly testing, would that always be on the employee or the employer?
The question is whether the cost of weekly testing would be on the employee or on the employer. Currently, that has not been addressed in the OSHA regulations. That being the case, I would assume that the employer could make that a requirement, that an employee who refuses to get the vaccine is responsible for paying for the test. I don't know how that's going to shake out.
And then part of that is whether they have medical and religious exemption.
The next question of that is whether there is a medical or religious exemption. So under the executive order that was initially published, it did include an exemption for medical or religious reasons. Not clear yet if that's going to be in the final text of the OSHA rule when it's published. So I know I said this was question and answers, and it's a lot of questions and not yet answered on this topic. So I'm gonna change that slide. Questions and unanswers. There you go. Yes, sir. Could you elaborate? When you say employees out.
Employees out for COVID, that we're required to pay them for their time off.
So the question is, as of July 1st, if you have an employee that is out for COVID, are you required to pay them, presumably under paid FMLA, for their time off? I believe, so that initial rule that was enacted the previous year expired. I think it's sunset. And so I don't believe there's currently a requirement to pay employees FMLA but I've got to double check on that to make sure to get back on you. And I will. We'll send something on that to see if that has been reenacted or not. Reissued.
If you give employees time off, that could be the payment with the PTO.
The question is, if you give employees time off, can that be considered the payment for like PTO? Same issue, because previously you could not detract that from their PTO when the lockdowns first occurred. They were making changes to that. I believe that you can now. I believe you can give them PTO in lieu of sick time or something along those lines. Any other questions? Yes, sir.
Picking up about what Shannon talked about earlier in his presentation about what California's doing with COVID, plus what's happening with the current emergency temporary standard with OSHA with regards to healthcare workers and paying them. Do you foresee that this pandemic, coronavirus in particular, will become an occupational disease and compensable through the workers' comp?
Great question. So in light of everything that is happening with the laws in California and more broadly across the country, the question is whether we can foresee if COVID will be considered an occupational disease and therefore compensable. It's a great question. Every state is going to have to answer that separately. I can tell you currently the law has not changed other than for first responders in the state of Florida with respect to it being an occupational disease. It is not yet classified as an occupational disease, could be in the future. That's probably actually a really great question for our next presenter, Chris Carmody, who's giving a legislative update. And that, I don't know if that's something that's on his radar currently or not. I haven't seen that trend yet. So in our work comp laws with the compensability issues, we haven't seen any deviation from the traditional standard of determining whether this is compensable, other than for the first responders, because the law did change in that area. Yes, ma'am.
Back to the religious exemption, we're seeing in a number of states where people are declining the religious exemption because they're not showing sincere health belief. And here, in Florida, we're seeing things like, well, here's your form, and you just say, well, it's against my religion, and not necessarily wanting to say anything more than that. And we've been advised to err on the side of just giving everybody that out. And I'm just wondering what you're hearing and seeing relative to religious exemptions, recognizing we can't give people a litmus test, but it would seem to be that just saying, well, it's against my religion.
So good question. The question is with respect to the religious exemption from the vaccine mandates. What is the due diligence that's required or allowed from employers to determine if in fact if this requested exemption is based upon a sincerely held belief, or is it just an easy out or excuse to be exempted from the vaccine mandate? So what can an employer do as far as drilling down into a claimed religious exemption to determine if it is a clearly held religious belief? So the answer is you can conduct a reasonable investigation and due diligence to make sure that it is a sincerely held belief. That is difficult to do sometimes, and I think that's why what I'm seeing is exactly what you stated, which is most employers are erring on the side of, if you're claiming that you have a religious exemption, fine. I don't know what to do with that, so okay, I guess you're exempt, because the laws haven't been written on that. Should this pandemic stay in place for a few years, and as you start to see the employment claims that start to arise from this, from people that are claiming discrimination, because let's say that they do, in fact, make a claim for religious exemption and it's denied, well, now you're going to be sued on an employment claim. It will take several years for the case law to come out to demonstrate what exactly you can do in that regard. But right now, most employers, the trends that we're seeing, most employers aren't pushing back. If somebody's claiming an exemption, they're saying fine. Some exceptions to that may, of course, be if you are in a high-risk category or if you are interacting with clients or patients that are at a higher risk. We do see our employers that are being more cautious before they're allowing their employees to go without vaccinations. Okay, any other questions on that topic? Yes, sir.
So, what Delta is doing with the surcharge, is that legal?
The question is what Delta is doing with the surcharge, the COVID surcharge. Is that legal? And remind me, this is the additional surcharge for passengers.
No, additional $200 for employees who aren't vaccinated on their health insurance.
Oh, on their health insurance. I'm sorry. Well, Delta believes it's legal. That's sorry. The question is, so Delta is currently charging its unvaccinated employees a $200 surcharge on their health insurance. And the question is that legal? The answer is maybe. Their attorneys have advised them that it's worth the risk of trying it to see if it's not. Great question. Isn't that similar to smoking? And yes, that's how Delta is justifying it. So if you are more at risk, if you are at a higher health risk because of your lifestyle, because of the decisions that you make, like smoking, for example, then it is allowable to charge a higher premium, and the employer who's paying for that can charge a surcharge. That is the way that Delta is using that for COVID vaccines. Is that ultimately going to be legal? If I had to guess, I would say probably, because there's some precedents, although different, but it has not yet been tested. Wanted to also briefly touch on some questions that we've had, evolving questions about medical marijuana versus drug-free workplace policies. So, of course, currently in the state of Florida, we are a medical marijuana state, not a recreational state. You have employees that are in your program, in your facilities, that have medical marijuana cards, and then they get in an accident. And you have a drug-free workplace policy. And so you send them to go get a urine screen, and it shows, yeah, they have THC metabolites in their system. What does that mean from a compensability standpoint? We've actually had this question come up a few times just in the last couple of months. So what does that mean from a compensability standpoint? It's easy if you do the screen and somebody shows that they have alcohol in their system. That's great. But what do you do with marijuana? The standard is the same as it has been even before medical marijuana, which is the employer can still have a drug-free workplace policy. And if your employee is injured on the job and you send them to get a drug screen, then you are entitled to a presumption as the employer, regardless of whether or not this is a medical marijuana state or not. So it helps. But the presumption is rebuttable, just like it is with alcohol, just like it is with anything else. It's a rebuttable presumption, and it's pretty easy to lose that presumption in a workers' compensation claim through any number of factors, really. Mostly, I think that presumption gets lost because the drug-free workplace policy wasn't followed correctly. That's where we see most of the issues with the presumption being lost, because if you do have the policy, you got to make sure it's followed and it's followed correctly. So oftentimes that presumption gets lost. But then the real question is one of intoxication. So sure, I have THC metabolites in my system. It doesn't mean I was intoxicated at work because, I consumed marijuana the night before my shift. I wasn't at all intoxicated the night of. It's still very hard. It's still very hard for law enforcement to determine appropriate levels based upon the THC metabolites and determining what that means with respect to intoxication, because everybody's different, especially based upon their own use. How often and how frequently and in what amounts are they consuming marijuana. So one person's THC metabolite level may not have any impact on them, and the other person may be locked on the couch for 3 days watching Netflix reruns with a bag of Cheetos. So it makes it difficult. But it is important to know that you are still allowed to have a drug-free workplace policy, even in the age of medical marijuana. It will still be the same in the age of recreational marijuana, if and when that happens here. You're still allowed to have those policies. You're still entitled to a presumption under the workers' compensation rules. That doesn't mean you win the case, and by any means doesn't mean you should necessarily deny the claim just because you had someone who has a medical marijuana card and they've tested positive. So it's going to be a case-by-case basis of determining kind of what the best approach is on that. So any questions on that? I know that comes up pretty frequently, but anybody have any questions on that specific question? No? Okay. We've got a few minutes. I see Chris is in the back, but are there any other general litigation or liability questions that I can help to answer now? Yes, ma'am. The question is, do I do auto accidents too? I try not to personally. But yes, sometimes accidents happen. I do handle automobile claims. So the question is, how do you analyze or evaluate a claim when you have an employee driving for the company and you know the employee was distracted, whether through cell phone data or GPS data, and that employee gets into an accident, and what impact does that have on the claim? So the company is still generally liable for that, even if the employee was distracted or not. It doesn't matter, so long as the employee was in the course and scope of their employment. So And that can happen if they're driving a company vehicle. That could also happen if they're driving their personal vehicle, depending upon their job responsibilities. If the employee is distracted, the company is still liable for that. That doesn't take them outside of the course and scope of their employment. We do see it a lot. It's definitely an issue that happens. What really happens to the second part of your example is your employee hits another person who hits another person, and are they all distracted? Yes, probably, because everyone's also on their cell phone. So witness testimony, witness statements are really important at the front end of that, making sure that that information is preserved. For significant accidents, that's where it's important to let everyone know so we can bring an expert in, because we're seeing more and more, pretty much on all vehicles now, including starting on some motorcycles, their data recorders are able to pull all of that information so long as you preserve it before it's gone. And that's really helpful to have on the front end. Yes, sir.
How much, if any, is our liability mitigated by us having all of this fancy equipment to give the information out that our driver is distracted?
The question is, how much, if any, is liability mitigated if you have equipment that tracks the data from the vehicle? So, whether it's a dash cam recorder or GPS or anything else, it can win the case. To answer your question, it can very easily win the case from the outset if you can demonstrate that your driver was not at fault. It can also be hurtful if it shows that your driver was at fault. But what it does do at the very beginning of that is at least you know. At least you know what the liability picture looks like. And in those cases, sorry, Chris, I'm going to get on a quick tangent here. If you know early at the outset that there's an automobile accident claim that you have liability for, those are the claims that you want to try to resolve quickly. Because here's the game. And this is true for your employees, by the way. Let's say that it's your employee that's injured, and they're going to be potentially bringing a UM claim, against your policy, even if they have work comp. So you would pay for their treatment. Or it could be a third party who has insurance. It doesn't matter. They will go the same day to Dan Newland or Morgan & Morgan and get signed up. Those attorneys will immediately send them to their doctors of choice, BioSpine or any number of these providers, and it's the same course of treatment for everyone, which is we're going to do some chiropractic care for a couple of weeks, then we're going to do some trigger point injection therapy, and then we're going to take out our knife and we're going to cut you open, and we're going to perform some surgery on your spine, which wasn't really required. And they're going to do all of this on what's called a letter of protection, which means even if you have insurance or even if you have workers' compensation, we're not going to run it through that. The doctors are going to triple their bills and leave it pending until the lawsuit settles, and then they're going to be able to get their payment out of the lawsuit. So for those claims where you know you have liability up front, if you can get those claims resolved before they go through this course of treatment, a $30,000 payment in July could save you a $100,000 payment in December, because after about 6 months, it's almost guaranteed they're going to have a lumbar laminectomy for something that didn't exist, or if it did, it wasn't caused by the accident. And now you're stuck because those bills are there. They haven't been written off. They haven't been negotiated. You're at mediation, and you say this was a nonsense accident, but you have a $75,000 outstanding medical bill. And now it's going to take $150,000 to settle this claim before the plaintiff gets the first dollar in their pocket. So to your question, does it help to have this information? It does, even in the times that it hurts. Even in the times where it shows that your employee was at fault, at least you know what the liability picture is, and we can settle it earlier if we need to. Okay, I think my time here is up. My name is Josh Walker. I'm with the Walker Revels law firm. Most of you have my information. If you don't, please find me. I'll give you a card. If you have any questions at any time, if I can help analyze any of your claims in advance, call me, email me, text me. We're always available to help where we can. Thanks for listening. God bless.